Hello and welcome to the Rodgers Brief for January 28th, 2023. I'm Adam Rodgers. Thank you for watching and thank you for listening. I'm going to be covering, as I usually do on a weekly basis, some significant court decisions and legal issues that are in the news in Nova Scotia and across the country. I'm a Nova Scotia-based lawyer, so often focus on cases that are in Nova Scotia, but these, as you'll see, some of them today have some resonance that goes just beyond Nova Scotia. Actually, there's a few national issues in the news this week too. I was listening to The Current a few days ago, and there was a segment about repatriation of some refugees, I suppose, in their sense, in one sense, but those who had gone to fight with ISIS. And the question is, does Canada need to repatriate these? Well, they're prisoners over in Syria. The obligation is apparently to repatriate these ISIS fighters and others that were associated with the Islamic State. But so that's on the go. That's a national story I was listening to earlier. The other one that was a big one this week was the merger of Rodgers and Shaw. And the merger had been approved at the federal court trial level, and it was appealed, and it was appealed to the Federal Court of Appeal and approved there again, approved clearly. And the Federal Court of Appeal actually said that the merger should increase competition, which would come as a surprise. Usually when you see a merger, that's a decrease in competition, but in their view, Court of Appeal's view, that was going to increase competition in the telecom market. So we'll see how that unfolds. I know many would have their doubts. The other one that was across the country was the out of Alberta this week. And I covered this story a few weeks ago, and it was a question of whether the Premier of Alberta had contacted the Public Prosecution Service. So this was similar in a sense, or had some similarities to the case where the Prime Minister had pressured his Justice Minister, Jody Wilson-Raybould, over the SNC-Lavalin prosecution, as it was at the time. So this one, the allegation was that there were some emails from the Premier to the public prosecution, or the Premier's people to the public prosecution office, about the trucker protest last year in Coutts, Alberta, at the border of the United States. And so CBC had reported that there were communications and written communications. It's emerged through the public service in Alberta that there were not. And so now the Premier of Alberta is up in arms about that, with the allegations, suggesting that she was engaged in improper political interference on that case. And it looks like there's no evidence of that, at least. So hopefully there'll be some apology, or some some consequences on the other side, or some at least acknowledgement from CBC that they jumped the gun on that one. Went ahead, I think, with they had reports that there were emails, and they published that. But when you say there are reports and you're the media organization that's well respected, then many people will take that as factual, and it certainly wasn't from what we know so far. The other one, it's a local issue, but it's I guess of national resonance in some ways. And I mentioned this before. It's a political issue, but it's also a legal issue, or it could become a legal issue. And that's the redistribution of federal ridings in Nova Scotia, particularly in Cape Breton. And one of the members of Parliament, Jaime Batiste, is up in arms over this. What happened is, so there were two ridings on Cape Breton Island, Sydney, Victoria, which is this old city of Sydney, plus rural Victoria County, which includes the north of some of the Highlands areas, into the national park, Badek. It's a rural county. And then the other riding was Cape Breton Council, which included some of the mainland and Inverness County, Richmond, Port Hawkesbury, but also the more urban area of Glace Bay. Well, now the redistribution has Sydney and Glace Bay together as an urban Cape Breton riding, and then the rest of the island, including significantly to Jaime Batiste, the community of Eskasoni, which is about half an hour outside of Sydney. It's a Mi'kmaq community, and it's part of the Cape Breton regional municipality around the old city of Sydney. So Jaime is saying two things. One, that they're being Eskasoni, where he says he's from. I'm not sure he lives there, but he's from there, he says, and has friends there, including the chief, Leroy Denny. saying that they're now being excluded from and separated from the main urban area of Sydney, where there are many connections, but then also that this is a violation, more so, I guess significantly in a sense, this is a violation of the United Nations Declaration of the Rights of Indigenous Peoples. And that declaration was put into law or incorporated into Canadian law by the current government. And so what that says is you need to have free, prior, and informed consent before you make major changes that have an adverse effect on Indigenous communities. And so the suggestion is here that that wasn't given in this case. Well, there were consultations. There were consultations all around the province. I attended one. There was one in Sydney. And then after the in-person consultations, which neither Jaime nor Chief Denny attended, apparently, there was an opportunity for written submissions. And again, they didn't provide any submissions at that point. And so it's difficult to now claim that there was no opportunity for consultation if you didn't take advantage of the very public opportunity for consultation when it happened. So the other part of it is that they're now separated from Sydney. They're part of the municipality, the larger CBRM municipality, but not now part of the riding, the federal riding that includes Sydney. Well, so are many other parts of CBRM. Lewisburg and Marion Bridge, the sort of eastern side of CBRM, that was already in Cape Breton Council, in the rural side, including Manitou, where Mayor McDougall is from. I'm not sure if she still lives there, but that's her home community. So that was already part of the other more rural riding. And there's other, the districts 2 and 3 of CBRM are almost entirely now been switched into what will be called Cape Breton Antigonish, the rural riding, including those Victoria County, Inverness, Richmond. And so it's not as though Eskasoni was the only part that was excluded. And there are other Mi'kmaq communities in the area too. I heard Jaime Batiste being interviewed last week by Steve Sutherland on CBC Information Morning, Cape Breton. And the question was asked, well, couldn't you just run in the new riding? Which seemed like an obvious response to whether the Indigenous community has been marginalized by this decision. Well, you could run and win in the new riding, perhaps. So it doesn't seem likely. It seems unlikely to me that a court would overturn this on a judicial review if that's an application that anybody intends to make. Jaime laid that out as a potential, second stage. But the first thing he's going to try to do is a political outcome, which is getting through the House of Commons committee that studies this to have them reverse the decision. To me, that seems improper. I mean, this is a nonpartisan tribunal that's designed to keep politics out of the redistribution, like you see so often in the States with the boundaries that they make there between the Democrats and the Republicans. Gerrymandering is the term you often hear down there. So improper political interference on the first instance, if they change it politically, and if they take it to judicial review, I just don't see them standing a chance there, given that there was ample opportunity for consultation, which they didn't take advantage of those opportunities. So no one to blame but themselves. All right. So those were some of the national cases, including a local one, which it'd be interesting to see if the Liberal government is interested in pushing back at all on the nonpartisan Elections Canada redistribution system that's been set up. All right, another case. This is the ongoing case in Nova Scotia, William Sandeson. I've been saying Sanderson, I think, in my video. Somebody pointed that out to me, and thank you for doing so. I want to have these names properly pronounced. Sanderson is such a common name, especially in sports. You see that name a lot. But William Sandeson, the medical student, or he was about to start medical school. That trial's been ongoing. I've been talking about that the last few weeks. This week, a couple of interesting things. There was a DNA expert who has found Taylor Sampson, the victim's DNA, on the bullet, which was recovered from the kitchen windowsill. It was found and extracted from the wood. Had Sampson's DNA in it, the victim's DNA on the bullet, and there was some blood splatter on the gun itself that they found. There was also DNA found on the shower curtain, a duffel bag and a tarp that were found in Truro at Mr. Sandeson's family farm. So it's not looking good for him. An interesting moment this week now. Justice Chipman, Jamie Chipman, that's hearing the case, gave a warning to the jury that they should not be influenced by anything they read in the media. Now, there were two things in the media this week. One was there was a Canada-wide warrant issued for one of a potential witness, a Crown witness, that's Pookiel McCabe, Pookiel McCabe. Now, Pookiel McCabe, not sure if that's he or she, was in the apartment next door, had apparently overheard some of the activities, the shot that was fired in Sandeson's apartment. And interestingly, this was part of the first case that was appealed successfully. And McCabe was interviewed by the private investigator who William Sandeson had hired, and that was never, nothing was ever done with it. The police, I think, had spoke to Pookiel McCabe, but nothing was coming of that. But after the private investigator interviewed McCabe, spoke to the police and saying, there's something significant here, you should check into it, then the police were alerted, re-interviewed, and circled back around to that, and in fact tried to use that did use that in the original trial. One of the things that led to it being successfully appealed was the turning over of the information from the private investigator to the police, private investigator hired by the defense. So interesting. I'm not sure how necessary McCabe is to the Crown's case. They seem to have a very strong case going already, but I'm sure they want to be thorough as well. So that Canada-wide warrant has been issued. So the jury is not to, they're not supposed to read the news or look into those things. They're not supposed to also read the news and look back on the reports from the original trial to see what happened then and, what they should know about the original trial, if anything. Well, they should know nothing is what the judge would like. And that's to try to keep some trial fairness in place for the defendant. Okay, a couple of other cases I want to cover. And sometimes I go 25 minutes, half an hour with these videos. This one's going to be a little bit shorter. It hasn't been too quiet a week, but there's just two more cases that I wanted to cover that I thought would be of significant interest or some interest. One was this case of DCS. DCS is the initials of the defendant, charged with a sexual assault of a stepdaughter out of Beaverbank, and was found guilty by the Supreme Court of Nova Scotia and Justice Norton. Justice Norton was appointed from Stuart McKelvey a couple of years ago, actually, and has a good reputation as a judge. Anyway, the issue was this is a criminal case. And by the way, the DCS, they have the initials because not to protect the defendant, but to protect the victim. All right. So knowing the defendant's name would tend to identify the victim. And so that's why they use initials for the defendant's name in these kinds of sexual assault allegations and these cases. So the defendant in this case confessed to the sexual assault, the activity, but tried to argue that because he had diabetes, that low or high blood glucose level could affect his thinking and concentration and lead him to make a confession even though he didn't mean to do so. Well, maybe he wished he didn't make the confession, but Justice Norton properly found that wasn't a good reason at all for having the confession excluded as evidence. That was so if the confession isn't voluntary, and if you don't have an operating mind, your confession can't be voluntary. So that was what the defendant was trying to show, that, well, I have diabetes, and he had sent the police to his house or apartment to get his medication. They came back with the wrong medication. He said, it must be in my vehicle. So they went and got it then. And then he took his medication and then made his confession afterwards. Well, there was no evidence that affected his concentration or his thinking in any way. He was a self-represented, although he had a counsel appointed by the court to assist him. It's not clear that a lawyer would have put forward this case. I mean, it's not a very strong argument. The other part, not only is it not a strong case, there was no expert medical testimony to show, here's what low or high blood glucose might do to somebody's thinking. If you're going to make an argument like that, a medical argument, you can't just go in, unless it's the simplest form of medical thinking, then a judge isn't going to accept that without some expert evidence to back it up. So in this case, it was a self-represented defendant, had confessed, didn't call any medical expert testimony, and was found guilty accordingly. Based on the confession, but also based on other evidence as well. All right, next case, last one I wanted to talk about, Weigel versus Kendall. This was out of the family court, Justice Cindy Cormier, and this was a mobility case. All right, so this is used to be quite common for when everybody was going out to Fort McMurray to work. There would often be questions of, well, should the child be moved to Alberta? Isn't that better? So the question is always, what is in the best interest of the child? Okay, so you look at the relationships that the child has. Now, in this case, it was a short relationship. So the couple themselves, they split up almost, just in the months following the birth of the child. Baby had some heart issues, had a specialist in Halifax, and had a doctor set up. Now 4 years old, it was 4 years old at the time of the trial. But the mom, Miss Kendall, had a job opportunity for a better job in Ottawa. Some of her family lived in Ottawa. Some good friends, so better support network for her. And the offer was for block time for the dad back in Nova Scotia. So the best interest of the child test is the physical, emotional, and psychological safety, security, and well-being. Now that is all affected by your parents and your parents' income, their jobs, their satisfaction to some extent will affect the well-being of the child. But what they look to is, whether the child's going to be able to, if they already have a group of friends, are they going to have difficulty leaving those friends? Are they going to be able to establish new friends? Well, in this case, the child's 4 years old. It's got some daycare friends, but not particularly significant relationships at that stage. So the younger, the better in that sense, if you're looking at a mobility case. They look to, are they involved in extracurricular activities? And are those opportunities going to be more available here versus there, or vice versa? Those sorts of things. And then the support network. So extended family members, friends that are close by. And the court will actually do an analysis of how close these extended family members really are to the child. And they found in this case that the dad's extended family wasn't all that supportive of the mom and the child. Dad had some other kids as well who he was parenting, and he's not a bad father, but he just wasn't all that involved in this child's life. So here was the interesting part. Well, a number of interesting parts, and it was a long, well-written decision. The court is not allowed to consider whether the parent who is planning to relocate or is asking to relocate would actually not relocate if the court said, no, the child's not going. So the judge is not allowed to consider that. Now that came out of a Supreme Court of Canada case in Barron-Dregd, if I'm pronouncing that correctly. And also the Nova Scotia Parenting and Support Act now explicitly says this, that the judge is not allowed to consider the question of, well, listen, mom or dad that's asking to move, if I don't allow this, are you still going to move? And because almost always the answer is going to be, well, no. If you have primary care, as the mom did in this case, and the court says, no, you can't move, well, most often the parent's going to stay back and sacrifice the promotion or whatever the job opportunity may have been. But you're not allowed to consider that because that would really undermine the whole request in the first place. So it's an unfair thing to put on parents, an unfair question to ask apparently. So that's that's how that's going to go. So the move was allowed in that case. Mom's moving to Ottawa with the child, and so hopefully that will work out. But if anybody's looking at mobility cases, this was a well-written decision, took into account all the factors, so that anybody would have to consider if they're looking at a move with children against the wishes of the other parent. Of course, if the other parent consents, then you're allowed to move, of course. So Weigel versus Kendall. Last one I guess I want to mention is this. It was in the news this week that there's some judicial vacancies in Nova Scotia. There's 4 vacancies. One judge is on long-term leave. I know who that judge is, and they're not coming back. And there's 2 others that are going to be retiring in the spring. So there'll be 6 absences or vacancies on the court. And it's having an effect. There's this particular, the Carrie Lowe case, who's alleged victim of sexual assault in May of 2018. She's made her name public. She applied to the court to do so. And Brent Julian, who's entered a not guilty plea, is scheduled for trial in March, just of this year, March 7th. But there's no judge available. He scheduled the trial. He set the trial date last July. And so what happens? If there's no judge available and you're beyond the Jordan timeline, so it would be 30 months on the Crown or court side, if it's their fault for 30 months that you don't have, 18 months for less serious cases, 30 months for indictable. If there's no judge available and the defendant can't have their day in court in that time frame, then cases could be dropped. So it's a serious situation. Provincial Department of Justice needs to get on that. People need to get their applications in to become judges. So those are okay. So those are some of the cases that were significant this week. Some national ones. I may look more into this Shaw Rodgers case and the one about the repatriation of the ISIS fighters. I listened to that on the CBC radio the other morning, but I haven't looked up the actual legislation to see what's involved in this repatriation of potential terrorists. But that's been done before and it's been managed. So by the sounds of it, it could be done properly. Anyway, those are the cases I thought might be of interest to you guys this week. Appreciate everybody watching and listening, and of course, like and share the videos if you think others might be interested as well. And until next week, thanks again for watching, thanks for listening, and we'll see you next time.